that 191 counts are too many. Whether the accused persons are convicted in 1 or 10 counts, since the counts are of this or similar nature. For example, if they were to be jailed for 10 years, my lady, since this is the occurrence, the alleged offense was committed between 1st of January 2021 and September 2023. If your lordship was to sentence after you found that they were guilty, it is obvious that the law would require that the sentences run concurrent. And the result in my submission will be the same. My lady, you look at the time that the prosecution will lead. They will endeavor to prove each and every one of those counts individually. Your Honor, this case will take years before the court. And yet, my lady, you are aware that the prosecution are objecting to bail. So that it will be extremely prejudicial to the accused person. They are in custody. The case is going to take an endless period in being determined. My lady, there is one point that I've just forgotten about the defective charge sheet. The state says that even if your lordship were to find that the charge sheet which does not disclose a specific period when the offense occurred. My lady, we are talking about a period of 3 years. If the accused was in Tanzania or was out of the country and he has been charged that between January 2021 and September 2023, how would he defend himself? I'm not sure how the prosecution is going to come up with evidence that all those days each accused person was available. We cannot wait until the matter goes on appeal. We have the opportunity now before you, and we are saying this charge sheet, which does not show the age of a deceased, the specific time the deceased died, the gender of the deceased, can never be said not to be defective. Our prayer, my lady, is that the charge sheet as it is today is defective. It should be struck out. And if it's not struck out, your lordship should give direction to the DPP to come up with a reasonable number of counts, which even the accused person can be able to say, I knew so and so. You can connect to that person, unknown child, unknown age, unknown gender, killed.
This court should be reluctant, even upon invitation by Mr. Kouko or any other defense counsel, should be reluctant to interfere with the decision of the DPP. Lady, this is a very important constitutional edict, the independence of the Director of Public Prosecutions, whom we represent here today. Charges before you are not defective. Section 134 asks us clearly what we needed to have included in the information. It says that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense. Each of our 191 counts lists the statement of the offense as murder, contrary to section 203 as read with 204. And then it says, with which the accused person is charged, together with the particulars as may be necessary for giving reasonable information as to the nature of the offense. We have given the statement of the offense as murder. We have given the particulars that all the accused persons in each of the 191 counts led to the unnatural death of the victims named and or identified. Identifying the victims whose unnatural death was caused by all the accused persons in respect of each of the counts. But my lady, even if, I'm summarizing, my lady, even if any of those charges were to be defective arguendo, then that defect is curable under section 382. My lady will have a chance to look at section 382. The legal question raised by Mr. Mouko that section 382 applies on revisions and appeals is new to me. Section 382 is applied by trial courts, both in the magistracy and before this court. I'm sure the learned judge before whom we are today has used section 382 along the ranks, not just in revision. So that does not arise. Delay. Lady, the only thing Mr. Mouko is not saying expressly when he talks about delay is that he's asking this court that we should take advantage of convenience, that we need to get over with this very fast. The accused persons are telling you that, we are tired of being before you. Hurry up. So for the defense, it does not matter that 191 children died. They want to get over it. We're asking you that this is an extremely serious matter. The 191 children are not vegetables. And if it will take a decade for them to get justice, we're asking this court to take one more day. So that the right to fair trial does not mean that you give convenience to accused persons without considering justice for the victims.
17 of May. So I've considered the submissions by counsel on the issue. The Prisons Authority are mandated to ensure the well-being and security of persons remanded under their care, and to take any legal measures necessary to ensure that this is done. In light of this, I direct that the prison authorities do discharge their legal mandate and ensure the safety and security of the accused persons herein. Where measures are required to be undertaken out of the normal ordinary operations and accused are required to be separated, I do direct that the defense counsel be informed.